informed. People who stay informed of the law tend to see opportunities where other people just don't. And also having a working knowledge of the law, or at least a bit of the law, gives you a better opportunity to know how to stay away from liability issues that arise as you own multi-unit real estate throughout the Bay Area. And never in my career has it been more cumbersome and tricky and difficult as it is right now because of the COVID pandemic and the different moratorium that we have faced throughout the Bay Area. So with that, Joey, I think we're waiting for the PowerPoint to pop up.
Okay, great.
There we go. So I'll be just asking Joey to anticipate when we're needing a change. Otherwise, I'll just ask you to make a change. I did have the questions that you sent in. At the end of this, I'll be happy to go over some of the questions you had. But the whole goal today is give you an update on where we are in Alameda County on the eviction moratorium, what's happening, and it's happening over the next 48 hours, which is exciting. An overview of state just cause rent control laws, an inquiry on permissible rent increases, how to deal with rent debt that has accrued throughout the COVID pandemic. And then a discussion close to my heart is how we can avoid tenant disputes while still accomplishing the goal of making good decisions about your real estate by potentially negotiating voluntary move-outs, which during the pandemic, especially in Alameda, was one of the only ways in which you could recover possession of units. And so that's what I'm hoping to cover during this brief review, and then I'll open myself up to questions. So with that, why don't we change the slide? All right, so Alameda County. Alameda County right now is home to one of the most draconian eviction protections anywhere. So there is a lot of misunderstanding that clients call me with, is stating, Mr. Bornstein, I heard that the moratorium is over as of July 1st. And the answer is, yeah, the state moratorium was over as of July 1st, but we have a local moratorium in Alameda County that covers all cities in Alameda County that remains in place. And that means that I can't do much for you at this juncture in the court system because there currently is in existence a prohibition against evictions, demands for rent, unless there are various exceptions. And this is all over the county. And just so you understand, having done this for 25, 28 years, I've been handling landlord disputes. And in the past, pre-pandemic, a client would call me up and say, Mr. Bornstein, a tenant owes me $3,000, $6,000, $8,000. I'd be like, why are you waiting so long for an $8,000 debt? And that's because it would be 2 or 3 months of unpaid rent. During the pandemic, I'm having people calling me up and saying, I've got $50,000, $70,000, $80,000 of unpaid rent debt. And that's primarily because the Alameda County moratorium has precluded evictions for non-payment of rent, and it's now going on in excess of 2 years. So let's look at the next slide so we can understand the moratorium and what's happening. So right now, the Alameda County eviction moratorium remains in effect until 60 days after the end of the local public health emergency is ended by the Alameda Board of Supervisors. The only exception is an Ellis Act, where an owner is going out of the rental business, a unit is being vacated because it's red tagged, such as a significant fire that poses a harm to the building or any occupants, or what is most likely, where we have a resident posing an imminent threat to health and safety. For example, arson, drug dealing, violence, vandalism. Those type of evictions have been permitted in Alameda County throughout the moratorium. But other than those type, we haven't really been able to get to the courts. A non-payment of rent eviction is not permitted. A subletting without permission is not permitted. A nuisance where we've got people playing playing music and partying at all hours of the night, typically not permitted. So I want you to recognize that this moratorium makes it impossible, except for very limited exceptions, to utilize the court to remove tenants from premises. The moratorium covers all of Alameda County. And I just want you to know that it doesn't apply to where we have licensees, maybe a family member who's living in a unit. They're not tenants. They were given permission to live in the unit and you want to ask the family member to leave. That's a license, not a tenancy. And those are still permitted during this moratorium. But most importantly, for you folks today, you need to recognize the moratorium remains in place. Local moratoriums are still in place in Alameda County. But since the county moratorium covers all of it, I'm looking at the moratorium. The court system is county-based. And until the moratorium is over, our hands are tied in Alameda County. Next slide. There have been attempts to try to get the supervisors to end the moratorium. But in a recent 3-2 vote, the supervisors refused to revisit changes to the moratorium. The only other county in California that has its own existing moratorium other than Alameda County is Los Angeles County. And they recently ruled to end their moratorium by the end of this academic year. I'm sorry, this calendar year. Alameda continues to have the moratorium. People have become so frustrated that, Joey, slide, that a lawsuit has been filed to force the Alameda supervisors to end the moratorium. Tomorrow, the 29th, a federal judge will hear a motion to end the moratorium. We are crossing our fingers and hoping that judicial intervention will result in the end of the moratorium so that owners can properly manage their property, demand non-payment of rent through the court, and potentially remove tenants under a pre-pandemic protocol following the local, state, or local just cause eviction rules, but at least we're open to the court. The arguments that are being presented to the court tomorrow is that it's a hardship on rental providers. And one easy example is that unpaid rent that has accumulated. Owners still have to pay them their mortgages, still have to pay utility bills, taxes, but they're not getting rent. There is no requirement of a tenant to prove a COVID-related rent distress in Alameda County. You're not allowed to serve a 3-day notice to pay rent or quit. That's a violation of the moratorium. Tenants can destroy the premises without necessarily facing the consequences of an eviction. It's a very small exception. And again, aside from the Bay Area and Los Angeles, the state moratorium is over. Thus, please stay in contact with either Joey or myself, and we will be announcing if, in fact, the federal court rules to end the moratorium. If they rule quickly, it would be ideal. It would be a gift. If they don't rule quickly, I will be following this. And my hope is that judicial intervention ends the moratorium as being unconstitutional. So this is where we are as of September 28th, 2022. The moratorium remains in place. However, there's a challenge to it driven by local real estate interest, California Apartment Association, and we're hopeful that the judge determines the righteousness of the position to end the moratorium so that the status quo pre-pandemic can emerge. Let's move on. Statewide. So when I first started practicing law, I had to be familiar with 3 local jurisdictions that had eviction, just cause rules, and rent regulation. It was San Francisco, it was Berkeley, and then it was Oakland. Now, throughout the Bay Area, there are 15 different jurisdictions with 15 different rent control and or just cause eviction ordinances. And when we look and someone says, oh, this city has rent control, you need to remember we're talking about 2 different things. We're talking about rent regulation and we're talking about eviction rules. They're separate, but they're often together in a singular ordinance. Where we have Oakland, where we have Berkeley, where we have Emeryville, where we have Richmond, where we have San Francisco, where we have Hayward, we have different ordinances. And if you own property in those locations, you need to be familiar with the local rules and regulations. If you're not familiar, you need to get familiar or at least develop a relationship with an attorney or a trusted confidant who will help you migrate the different rules and regulations. We don't expect you to know everything. We expect you to be familiar with it so you're not making imprudent decisions about your real estate investments. Recently, though, pre-pandemic, a few months before December 2020, the state imposed just cause eviction rules and rent regulation. So generally, except for new buildings that are 15 years old or less, single family homes and condominium units, your property in Walnut Creek is going to be subject to state rent control and state just cause eviction rules. If there is a building in Oakland, Oakland's ordinance is more restrictive, so Oakland's ordinance is what you follow. Understand? Outside of places that don't have their local jurisdiction, you're now following state rules. And let's go over the state rules. I could not go over the 15 different rules in the 15 different jurisdictions, but generally state rules are as follows. We have rent increases that can be no more than 10%. They're 5% plus the CPI, no more than 10%. Landlords must have a just cause to evict for any tenancy that is 12 months longer or more. Most single family homes and condominium units are exempt from state just cause eviction rules and rent regulation unless they're owned by an LLC where one member is a corporation. As I told you before, if it's a 15-year-old building or less, it's exempt. When it becomes 16 years old, the building falls within state or local state rent control. Remember, it's 12 months before a tenant is protected under the state ordinance, which means you could technically sign a 10-month lease in Walnut Creek, and that tenant doesn't have state just cause eviction protections or local protections. And then there are relocation payments for no fault evictions, such as an owner moving into the premises, an owner terminating a tenancy for substantial rehab. What you get under the state ordinance is the equivalent of 1 month credit off the rent. In San Francisco, the relocation payments for a local owner move-in eviction can be in excess of $25,000. In Oakland, it's $12,000. Under the state ordinance, it's the equivalent of 1 month's rent. So all things being equal, the state rules are less restrictive, are easier. For instance, annual rent increases can be between 5 to 10%. In Oakland, they're capped at what? 3%. Got it? So we know that their local jurisdictions are much more restrictive. And as I mentioned at the start, right now, Alameda has a moratorium on evictions. So all of this is academic until that moratorium is lifted. Let's go to the next slide. What are the just cause evictions under state just cause rules? And these are pretty much mirroring what's available in Oakland as well, under Oakland's ordinance, or in Berkeley under Berkeley's ordinance. Breach of a lease, such as subletting, nuisance, waste. Waste would be flooding a unit, leaving a spigot on and it destroys the building and costs $50,000 to remedy. Refusing to execute a extension on a lease. Criminal activity, assigning and subletting, refusing access to an owner after being given written notice to cease refusing, using the premises for an unlawful purpose, such as prostitution, such as drug dealing, gambling houses, an employee who is given a license to live there, rescinding the license after they're terminated. For instance, you have a resident manager, their resident manager position is ended, you can ask them to leave. And then this is one that's not available in Oakland or any other local jurisdictions for just cause, where a tenant gives written notice and they don't move out if the owner has accepted their notice. In Oakland, in Berkeley, a tenant can give you notice that they're moving out, and the day before they're supposed to move out, they rescind their notice of terminating their tenancy. There's nothing you can do except get upset because you don't have a just cause under the local ordinance to evict. Rescinding a notice of termination by a tenant is not a just cause. Under the state law, it is. I'm bringing the state law into the mix so you understand it and recognize if you're looking at other jurisdictions throughout the Bay Area that don't have a local ordinance, you need to be familiar with the state ordinance. Let's move on. Under state law, there are no-fault evictions. And what does a no-fault eviction mean? It's no fault of the tenant that their tenancy is being terminated. One of them is for an owner move-in or a family member move-in. Another is where you withdraw the rental unit from the rental market, such as an Ellis Act, where you intend to demolish the unit or substantially remodel the unit, or there's a red tag, number 4. I want you to see that that substantial remodel option is a very interesting option. Let's say you're in Walnut Creek, and I use Walnut Creek because it's close by. You buy a 6-unit building, it's over 15 years old. You immediately know it's subject to state just cause eviction rules. It's a tired building. The tenants are potentially long-term tenants who are paying below market rent. The building needs to be remodeled, updated kitchens, updated bathrooms, and you need to put a new roof in, and you need to update the electrical. You can terminate 5 of those tenancies, give the tenant the equivalent of 1 month rent to move out. The unit is vacated. You now can then do your substantial remodel, and then you're able to re-rent it at market rate. Under the state law, you don't have to offer the unit back to the tenant you displaced. In Oakland, Berkeley, San Francisco, if you do a capital improvement or a substantial remodel of a unit, if you need to terminate a tenancy to effectuate the remodel, the tenant has the right to come back in. This is another example of why, in some respects, the state law is bittersweet. It is a state just cause eviction ordinance, but it is certainly not as aggressive as the local ordinances. It gives you more room to maneuver, and it gives you opportunities that other people don't see, which is you can buy a building that's under market, that's sold for below market because it's tired, it needs to be repositioned. The selling agent discloses it's subject to state rent control and state just cause eviction rules, and you immediately recognize that, hey, I'm going to substantially remodel the units. I'm going to contact Mr. Bornstein, and he's going to help me terminate the tenancies after I get those permits, remove the tenants, clean up the unit, put new tenants in at highest rent, and then either capture the upside on the cash flow or sell the property as a repositioned asset. And this is an example of why working with Joey and working with an attorney who understands the ordinance is not simply about getting an understanding of traditional cap rates and traditional gross rent multipliers or what the law allows. Knowing the law gives you an advantage to seeing things that other people don't see. The best real estate agents are understanding this. Some of them have a working knowledge of it. Some of them don't. My suggestion is work with people who understand it and stay in close proximity with an attorney who's aware of it so that we can discuss options for you whenever you look at a real estate investment so that you can know what can be done and what can't be done. And what I will always do is first ask you where the property is located. Is it a multi-unit property? When it was built? How long are the tenancies? And with that type of information, I'll be able to go through a filtration process and tell you what's possible and what's not possible. And those 30-minute meetings with me are very helpful when you're evaluating a real estate investment. Let's move on. Rent increases. Many of you have come to me and said, Daniel, I want to do a rent increase. And I have to caution you, during the COVID pandemic, there are limitations on any rent increase in different jurisdictions because of the pandemic. And then there's also, you may have the right to a rent increase, but the optics of raising rent during the COVID pandemic are such that you may want to reconsider even doing so because you don't want scrutiny on your property. Remember, housing is very politicized right now. Doing something super aggressive can create opportunities for people to look at your property. There are a number of nonprofits that work on behalf of tenants. So you want to be smart when making a decision about renting or raising rents throughout the Bay Area. Let's move on. Rents have ticked up a bit, but we have to understand they have not caught up to pre-pandemic levels. And rent increases under rent control, you need to be aware of the rules and regulations. If you impose an improper rent increase, you've got an unlawful rent increase, and collecting rent on an unlawful rent increase is a violation of the law. And if you ever try to evict someone for non-payment of rent, when you have an improper rent increase, you lose the non-payment of rent case because you weren't entitled to demand the rent because you have a bad rent increase. So you've got to be very careful what you do. And it's not what you know that gets you in trouble, it's what you don't know that gets you in trouble. And pulling documents off the internet from Nolo Press, or not being aware of the rent ordinance, or not being aware of different moratoriums or different emergency rules creates risk for you. Let's go over quickly the ordinances in place. So we have a new CPI, and then we have a new rule that you can only impose 3% increases in Oakland. In Berkeley, we have 2.1%. Antioch, which I thought was an attractive place to look for opportunities because it's now connected to the BART. What did they do? They basically imposed rent control in Antioch and just cause eviction rules. Richmond has its own ordinance. Hayward has its ordinance, and it has an emergency measure as well. San Leandro has an ordinance as well. I will tell you, if you ever look at a property in any of these jurisdictions that you're considering purchasing, the first thing you do is Google tenant rights in San Leandro, and you're likely to quickly find the local ordinance because it's typically published by the city government. And then you do your review and research. And I used to have an encyclopedic knowledge of the Berkeley, Oakland, San Francisco ordinance. But now with all the different ordinances, I have to take a break before someone calls me, and I have to pull that ordinance up before I can competently speak about it so that I don't confuse one ordinance with another, because they all have different iterations. They all have different rules. They all attempt to protect tenants, but some are more disciplined and more restrictive than others. When looking at whether you can rent increase or not, you need to know about banked rent increases. Under the state jurisdiction, there are no banked rent increases. Under local jurisdictions, there are. Have you complied with your obligations under the rent board? There is rent registries. There are payments you have to pay that you need to be in compliance with before you can raise rents. What are the rules regarding how often rent increases can be raised? How are base rent calculated? Did you reduce the base rent during COVID? And strategic, if you got a great tenant and a aggressive rent increase may cause the tenant to look elsewhere, you may wish you didn't raise the rent because they left you. So we always want to be strategic. And when people talk to me about, well, what should I do? I ask them, and I tell you, rent increases is not a math problem, it's an art. Do you want to raise the rent so that you end up pushing someone out? Or do you want to create a rent increase that's digestible? And if you have a quality tenant with a great job, you may be better off not raising the rent right now because of COVID and waiting some time and letting the tenant know that I'm waiting time because I know it's a tricky time, but I will be raising the rent in the future. Master tenant issues and subtenants are another thing you need to be aware of. Please be familiar with the local ordinances, the local restrictions before you decide to rent increase, because I've got people who have raised rents improperly, and then only after they start a non-payment or rent eviction do they recognize that they have improper rent increases. Good tenant attorneys are always looking at the rent history to make sure that they can defeat a non-payment of rent case based upon an improperly imposed rent increase. Let's move on. To add insult to injury, there is a state law that allows a local official or the governor to declare emergency. And when they declare emergency, there's an anti-price gouging component. And your county that's exposed to a fire, that's exposed to an earthquake, that's exposed to monkeypox, that's exposed to COVID, can have the governor issue a warning and an emergency decree, and then you're stuck, not entitled to raise rents on a existing tenant, regardless of whether it's a condo, a single family home, new construction, or what have you. And also, the law covers even vacancies where you can't raise the rent from $2,000 to $4,000 after a vacancy because of the emergency ordinance. Why I bring this up is because there are existing ordinances in place right now on state of emergencies throughout California for different counties. Before you raise the rent, be advised, recognize that you want to make sure you know if your county is subject to an emergency ordinance. Over the last couple years, I have never had more laws come into effect, more moratoriums come into effect, more emergencies come into effect to really hamstring landlords, property owners, property managers, and what they can and cannot do throughout California. Why I mention this is to caution you. It's a very difficult environment right now. We have price pressures. We have the politics of housing. We have the optics of trying to displace people during a time of crisis. We have public policy trying to stabilize housing as opposed to creating vacancies. And so you need to be smart about how you manage your properties. And I'm here always to help you out. COVID rent debt. Many of you are holding COVID rent debt. Likely that you will have lost income because chasing tenant for rent debt is a race to the bottom. However, there are protocols to follow, and let's talk about them. When the Alameda moratorium is over, you will likely be able to proceed with non-payment of rent evictions in Alameda County for accumulated rent debt. Before proceeding, though, we will need to know under what circumstances you'll be able to demand it through a 3-day notice. Right now, you can proceed in small claims court for a COVID-related rent debt. It's simpler, it's less expensive. However, you don't get an attorney representing you in small claims court. You have to represent yourself. And if you're holding $40,000 to $50,000 of COVID rent debt, and your tenant is a doctor seemingly wealthy, you may decide to go to superior court, not small claims court, to demand that rent debt through a judgment. So you do have the option of small claims. There is no jurisdictional limit for COVID-related rent debt, but you do risk not having an attorney. Superior court is more expensive. You will have attorney representation, and you're more likely to accomplish your goal because you have an attorney involved. Small claims court can have a judge who's a voluntary attorney who can be dangerous. I'm happy to meet with you and discuss your rent debt and also help you make a determination as to whether we're going to go to small claims court, whether we're going to file in regular court, whether we're going to waive the debt because it's not worth it because the person's judgment proof and destitute, or whether we're going to wait until the moratorium is over and try to seek the debt through an eviction action. The problem with going to small claims court or going through a judgment against a tenant is that if it's only a judgment, it's a piece of paper that says the person owes you the money. You don't get possession of the premises. Evictions give you much more leverage because the tenant risks losing their housing if they don't pay you the rent. So before we decide to go to small claims to recover rent debt, we want to really have a talk about where we are. And during the month of September, I've been talking to a lot of clients about let's wait until September 29th. Let's see what goes on at court. Maybe they end the moratorium and things open up and we can be more aggressive. I want to let you know there was a state bill that would have paid rent debt for people who did not qualify for COVID-related rent relief. The measure failed. And that's unfortunate. Also, because so many people have suffered during COVID with loss of work, garnishing wages may be inherently problematic on a COVID-related rent debt. Generally speaking, chasing tenants for unpaid rent debt is a race to the bottom. You can spend a lot of time and energy and you don't actually recover much. And so I want to caution you, if the debt is $5,000, you're better off waiving it. If the debt is $50,000, then you've got to pursue it. But remember, you can pursue rent debt and all of a sudden the day before the trial, the tenant can go into bankruptcy, right? So don't think that it's an easy process collecting rent debt. What I'd prefer to do is if we've got rent debt, maybe use it as leverage to either get some payment made, a portion of it, or potentially negotiating a voluntary move out. And let's move on. So a voluntary move out is where you negotiate a voluntary agreement where a tenant vacates in exchange for something. In the past, it's been a rent waiver and some money. Where we have accrued COVID rent debt, it may be a rent waiver in exchange for just vacating because the rent debt is so high. And what I'm doing during the COVID pandemic is I'm writing tenants letters saying, look, even though there's a pandemic, there's an Alameda moratorium, you still owe the money. The rent is still accumulating. If you'd like to talk about it, please let me know because we're happy to negotiate a voluntary move out. I want you to know during COVID, I was not sitting at home. I was in my office. What was I doing? Not filing lawsuits because Alameda County moratorium precluded me from doing it. What I was doing was negotiating deals for clients trying to recover the unit because all things being equal, a vacant unit is preferable to a tenant occupied unit where they're not paying you the rent. We always try to unlock cash flow by getting a vacancy. A vacancy will allow you to put in a quality tenant, hopefully, who's paying you the rent as opposed to a tenant who's not paying you the rent. Remember, with buyout agreements, you've got to know the various jurisdictions. San Francisco, Berkeley, Oakland, Richmond, they all have different rules. Alameda City has a different rule regarding buyouts. They have different disclosure requirements. When we do a buyout, we're not just giving the person money or a rent waiver to move out. As part of the agreement, they're giving up possession and giving up any claim of any lawsuit against you. They're giving you a complete release of claims arising out of their tenancy. That's important. You don't want any residue after this person moves out. The real estate industry uses the term cash for keys. That's a misnomer. We're not just giving them cash for the keys. I'm giving them something to vacate and expecting that as part of their vacating, they sign a complete release of claims arising out of their tenancy. If you give a tenant money to vacate and you don't have any written documentation, the tenant can take the money, vacate, and turn around 2 weeks later, have a respiratory illness and then sue you because they had mold in their unit and you didn't have a complete release of claims. So you can be sued. So you want to have a good buyout agreement prepared, typically by an attorney. I'm preparing them all the time. I'm probably one of the attorneys so busy with buyouts because I'm a big believer of it. Using money to accomplish the vacancy will increase the value of your building. If you're preparing a building for sale, oftentimes getting a long-term tenant to voluntarily vacate will increase the value of the building. And so that's what I'm focused on, and I'm happy to help you out in that process. With the 30-minute meeting, I can coach you on how to handle it. And then if you come to an agreement, I can prepare the buyout agreement for you. That's code compliant, filed at the particular rent ordinance, and drafted compliant with the local rules and regulations of the ordinance. Next page, please. So please remember, there are ballot initiatives in November. We're going to look in November and potentially have all Oakland real estate subject to just cause eviction rules, residential. They're enlarging just cause eviction rules to cover newer construction in Oakland. Tenants do have a right to organize. I'm just handling a tenant union in San Francisco. And then state legislation is always forthcoming on housing issues. Be smart, stay informed. Your best solution is doing what you're doing right now, which is participating in this webinar. My goal is always to help educate people. I can't give you everything, but I can give you a taste of the complexity of what we're faced with. And knowing that you now have a resource with myself or Joey to help you manage and migrate all of these different issues. And with that, I just wanted to thank you for staying focused. I gave you about 35 minutes of intense communication. And I'm happy to answer questions as they pop up, and I'll leave it to Joey to have me answer the questions. If you change the slide, I want to let you know that I have a team of attorneys in the office. We speak Spanish, we speak Mandarin, Cantonese. If you want to be on our mailing list or get our e-blast, just email me and I'll get you on our list. We do religiously keep people informed by e-blast and updates to keep everybody aware of what the laws are. And it's always a pleasure to educate, and it's my privilege to be here for you. So with that, I can try to answer some of the questions that were submitted, or I can answer questions as they evolve.
Thank you, Daniel. First of all, thanks for such a thorough presentation. We do have a number of questions that were submitted during the registration, and then some additional ones that are being put in the chat box now. Again, anyone that has a question, please put in the chat box and we'll try to get to it. First question for you is, Daniel, and let me start.
And Joey, just not to interrupt you, I have the list of questions that were submitted, and I can go right through them if we're intending to go through chronologically, if you'd like me to do that.
Some of them, many of them I think you covered. And so I have some ones, given that we've got about 15 minutes left, I was going to kind of pick and choose some ones first, if you're okay with that. You mentioned about tomorrow is a big day around the judgment on the emergency ordinance, the moratorium. Let's just say we have a favorable judgment tomorrow, meaning that they lift this emergency moratorium. You mentioned about local moratoriums, Berkeley, Oakland, all these cities have local moratoriums. What does that mean, even if we get a favorable judgment tomorrow?
Very good question. We don't know what it means. And the reason why we don't know what it means is because we have the confluence and interrelationship between a county moratorium and a local moratorium, and local moratoriums have triggering events that haven't occurred yet either. So Berkeley's moratorium remains in effect, Oakland's moratorium remains in effect. Our hope, though, is that the broad action by the court with the Alameda County moratorium may result in those other moratoriums actually no longer being effective. I will let you know that this is very, very tricky. For example, in San Francisco, the state moratorium ended July 1st. San Francisco established a new moratorium July 1st that made COVID-related impact financial a defense to a non-payment of rent eviction. So we are in a cat and mouse game, and I have to admit that it is not clear what the impact will be, and it will often be dependent upon what the judges rule. What do? Do they direct the Alameda supervisors to immediately end the emergency. And then it will trigger 60 days, the end of the moratorium. Do they do nothing? And so I can't give clarity as to what will transpire, but I will say that watching what happens with the Alameda moratorium will be most persuasive in knowing how to handle things thereafter.
Okay. I had a question around owner move-in evictions and whether or not these restrictions also apply to owner move-in evictions.
In Alameda County, you cannot do an owner move-in termination at this point in time. If you recall the slide that was presented, red tagging of a building, Ellis acting of a building, or health and safety is the only permissible evictions at this point, which means, think about it, for 2.5 years, there've been people who have bought property expecting to move into a unit with that's tenant occupied, and they've been waiting for 2.5 years to actually recover possession of a unit. You can't serve a termination notice. Serving a termination notice in Alameda County for an owner move-in eviction is in fact a violation of the law and can subject you to criminal penalty.
Got it. Question around rent increase. You mentioned in one of your previous slides the allowable rent increases for each city. Just generally, are rent increases allowed right now?
Generally, they are. Generally, they are, but you have to follow the necessary ordinance to make sure you're doing it correctly. However, please be advised, San Francisco is taking the position that there still is an emergency ordinance that precludes increases over 10%.
Can you repeat that one more time?
San Francisco is taking the position that there is still a local emergency in place that precludes increases over 10%. I have been doing increases in Alameda County, especially on condominiums and single-family homes. And it's just on a case-by-case basis. If you have a multi-unit property in Oakland, we've got to be very careful about how we handle the ordinance. I will let you know that the rent board is still active and tenants are still filing wrongful rent increases or decrease in service petitions at the Oakland Rent Board when you violate the rules.
I have another question about a master tenant and a subtenant. And can a master tenant be responsible right now for a subtenant who violates the lease?
Absolutely. A master tenant who signs a lease agreement with you is subject to the responsibility of compliance. And to the extent they have a subtenant who's contravening the terms of the master tenant lease, you can enforce it. There's one overall issue, which I have repeated ad infinitum. If it's a small breach, like the subtenant brought a pet to the premises and you have a no pet agreement in the lease, you can't enforce it. It's not a health and safety issue. So what we have right now is a lot of people in violation of their lease in Alameda County, but the enforcement is impaired because of the moratorium. Once the moratorium is over, I'm happy to be aggressive in enforcing lease terms, because in Oakland, in state law, the state just cause eviction rules, a breach of a lease agreement is a basis to evict.
Okay. Daniel, are you aware of Richmond's Measure P, which basically adjusts the maximum allowable rent increase? And had one of the participants ask, what is your opinion about it in terms of whether it'll pass or not?
Oh, I think it's likely to pass. Here's the problem right now is that because of the nature of our economy and because of where we are in terms of the percentage of people rent versus own, the likelihood is that these type of ordinances that are favorable to tenants pass. The only hope in my mind is that we have more single-family homeowners and people who are typically voting go out and vote, because if you miss an opportunity to vote, you're really putting yourself at a disadvantage.
Okay. I had a question around the eviction process per city, and just they wanted to understand, is it the same throughout California or does it differ per county?
All right. So we have, if the local jurisdiction does not have a local just cause eviction rules or local rent control, then you're going to follow the state law. And once you follow the state law, you serve a proper termination notice. The tenant doesn't move out. The process of eviction in court is the same everywhere. However, where we have local jurisdiction rules, there are different processes that you must follow before you file the lawsuit in court. For example, in Oakland, before you can serve a cure or quit notice for a lease violation, you have to give a tenant a notice to cease violating the lease. So in Oakland, there's an extra notice requirement before you can serve the eviction notice. In San Francisco, we just have a new notice requirement that mimics Oakland's. And so different jurisdictions have different nuances, and you need to know those nuances, because if you just go on the internet and review landlord-tenant law for Nolo Press, you're going to get yourself in trouble. And also, you have a cousin who practices law in Santa Barbara, who practices personal injury law, but he's your good cousin, and you say, I've got a landlord-tenant law question, and they prepare a notice for you in Oakland because you don't want to pay for a local attorney. They're as dangerous as anybody, because you need to have an attorney who's practicing in that jurisdiction all the time. For example, if someone calls me up and they have a San Jose eviction problem, San Jose has its own ordinance. I will refer it to an attorney who's handling San Jose evictions, because one, I don't want to drive all the way down to San Jose. It's too expensive for a client. And two, that attorney is in that ordinance all the time. So when you hire an attorney, you want to say, Mr. Bornstein, do you do non-payment of rent evictions in Oakland? Do you do non-payment of evictions in Berkeley? Do you appear at the Berkeley Rent Board? Those are the type of questions you want to fine tune, because a landlord attorney who's practicing in Santa Rosa is not going to be familiar with the Oakland or San Francisco ordinance. So you really want to recognize that you've got to be niche specific.
Question around renewing a lease, whether it's a month-to-month or a term lease. If the tenant refuses to sign a new lease, is that a cause for eviction?
In state law, it is. A refusal to extend a lease for the lifetime term, it is. In Oakland, it is. However, in Oakland, in San Francisco, it's seldom a real basis to terminate. And the reason being is that if you start the process of terminating, you're likely to have the tenant sign the lease agreement and then you're done, right? So I have not seen ever evictions on that type in local jurisdictions. San Francisco has a just cause provision where after the expiration of a one-year lease, if you offer the same lease for another one-year period, but for the increase that you're permitted and the tenant refuses to sign, it says on the books you can terminate the tenancy, but it's seldom used as a viable termination.
Tenant who is harassing other tenants, is that an evictionable offense?
Absolutely. Tenant disputes, tenant harassment all the time. And that during COVID, with more people inside their units because they're not migrating to work, more and more tenant disputes, and a tenant who is creating a substantial and unreasonable interference with the use and enjoyment of other people's premises is entitled to be transitioned out of the property. And it's easier to proceed with a tenant dispute where a tenant is harming the community than it is a landlord-tenant dispute. And even though the landlord is pursuing it, when I am able to say, look, people are paying monthly rent with the expectation of quietude, and you're banging on the walls, you're yelling, you're screaming, you're doing drugs, you're having people loiter in the building, you got to leave. It's not fair to everybody else who's timely paying the rent. Those type of evictions are perfectly acceptable. The only thing in Alameda County is that it's got to be health and safety. So if it's just noise, they're playing their music too loud at night, right now, that's not viable. After the moratorium's over, there's a process. If there's a lot of partying and it's obnoxious and you've properly documented and you've called the police a couple times, that's a basis to start the process.
I have some questions around when to start the eviction process. So for example, if you have a tenant who's not paying rent, right? When does it make sense to approach them either with a buyout attempt or serving an eviction notice?
Right. So assuming there was no moratorium and we were pre-pandemic, I'm not waiting very long to serve a 3-day notice. And the reason why I'm not waiting very long to serve a 3-day notice is the eviction process in court can take up to 3 months. And if you wait 4 months before you tap a tenant on the shoulder with a 3-day notice, and then you got another 3 months, it's 7 months of lost rent. And a week before the trial, the free tenant attorney will say they'll move out, but give them another 8 weeks and waive all the rent and give them $5,000. So for me, when I'm initiating a tenancy, I will say to the tenant, you know, I want you to have a great time at this place. We have a great community. If you ask me for a repair that's legitimate, you're going to expect me to provide a rapid response. And I'm going to do so because I'm committed to maintaining a great building. The only thing you have to understand is that if rent is not paid by, you know, the first of the month, I am going to serve a 3-day notice and or, you know, the 5th or whatever. And the reason I do that is because I treat everybody the same. And I do need the money. And if you, if I tell you now that that's going to happen, I don't want you to be upset when it happens because I'm letting you know that that's how I handle my affairs. The 3-day notice doesn't get paid on. We file the lawsuit. It takes 90 days to work itself through the Alameda court system. And so you're likely out 4 months of rent. And remember, a week before the trial, the free attorney says they'll move out in 8 weeks, waive the rent, give them money, right? And you're already $10,000, $15,000 in the hole in lost paid rent. They want 2 more months. And the reality is a jury trial will cost $20,000. So are you going to give them extra time to move out and waive the rent? Or are you going to go to a jury trial with someone who's not able to even pay their rent? So the economics of dispute resolution in landlord-tenant matters requires you to be pretty quick to get those notice demands. Right now, because you can't get to the court, doing a buyout makes sense, right? And also, I want people to recognize that an eviction lawsuit is really a leveraged buyout discussion. And what do I mean by that? 98% of all cases settle. They typically settle with the tenant moving out. If you're involved in an eviction lawsuit, you have the leverage of potentially going forward with a trial if you can't get to an agreement. So a buyout in the context of filing a lawsuit will give you a better likelihood of getting terms that are attractive to you. If you do a buyout right now where the tenant knows there's an Alameda moratorium, the tenant will say, waive my $40,000 and give me $10,000 to move out. And you don't have much to do because you have no leverage because you can't get to the court. So that's the sort of thought behind it. I would always try to do this as quickly as possible.
You know, it's hard to believe, but it's almost 4 o'clock. Thank you so much for taking the time and sharing all this valuable information with us and for everyone coming out to just join us today. We have the presentation deck here that, Daniel, is it okay if
It's my pleasure to distribute it. And look, I know that there are more questions. If you email me and it's a quick question, I'm happy to respond. If it takes a little bit more time or if it's specific to a particular dispute, I'll let you know that I'll have to have a half-hour meeting with you. But generally, it's my pleasure to help you folks out. And, you know, this is all great. And, you know, being informed and educated is really your recipe for avoiding further liability and also maximizing opportunities for you. So it's my pleasure to be here. And thank you very much, Joey, for inviting me. I'm happy to come back. So
awesome. Love to hear that. And, you know, as I mentioned earlier to the group, I'm planning to put more of these webinars together on topics of interest. And actually the next one scheduled is going to be for October 19th. And that's going to focus on property management. Sam Sorgan he's the founder of Premium Properties. He's going to be on there. He's going to be talking about common ways people mismanage and undermanage their properties. And he's going to share tips to do before the winter to really protect your property and save money. So I'll be sending out an email to everyone here and keep your eye out for that. And finally, I'm going to be sending out a short survey after this, and I would really appreciate you guys to just complete that survey. Any feedback would be appreciated.
Perfect.
Thank you, guys.
Thank you for inviting me.